So guys, welcome once again to another episode of Scott Talks Law. So this is part 2 of the episode on choice of law rules. So the first episode on choice of law rules, I did it in a live session. So you can go through the first episode before going through this episode. So the first episode was interrupted and I had to do a part 2 of the same. So in the first episode, we talked about, first of all, under the choice of law rules, um, we were to define choice of law. We were to define domicile and types of domicile. We talked about domicile in the previous episode, and we were also going to talk about choice of law rules in regards to the enforcement of contracts and choice of law rules in regards to tort. So in the first episode under choice of law rules, we talked about choice of law rules, and we said it's a set of rules that a domestic court uh, considers. So these are set of rules that a domestic court must consider, and for a particular issue or dispute that has arisen, a dispute with a foreign element, it will force the domestic court to go and consider the rules that that domestic courts have, consider their laws, if they are forum convenient or forum non-convenient. So a domestic court will go and look at their rules, their statutes, their provision to see if they are in the rightful position to settle that dispute amicably. So if they are not in that position, then they refer the dispute to where it had emanated. So the choice of law rules is the choice of law that a domestic court chooses, or the appropriate laws that should be applicable to resolve that particular dispute. So we also talked about domicile, and we talked about the ways in which one can acquire domicile, and we talked about domicile by origin, domicile by dependency, and domicile by the third type of domicile is the one that you apply for it. That domicile when you have attained domicile by choice, you have attained the age of majority 18 plus. So those contents are the previous episode. You can go through that episode. So in this episode, we are going to talk about choice of law rules in regards to the enforcement of contract and tort, or in regards to contracts. So in Kenya, there is no statutory provision, but we rely on common law in regards to choice of law rules in regards to the enforcement of contracts. So common law gives us two major approach when talking about choice of law rules in regards to the enforcement of contracts. We have got the party autonomy and the law of the place with the most real and substantial connection. The party autonomy and the place with the most real and substantial connection. So we're talking about choice of law rules. The laws that are to be used are based on two approaches: party autonomy and the place with the most real and substantial connection. So under autonomy, you have got express autonomy and implied autonomy. So express autonomy, the party states the law of the place to govern their contracts. It should be clearly stated, and there a clause may be provided for the place, and that clause is referred to as governing clause. So if this was a contract that was between parties, one party stays in Colorado and the other party stays in Kenya. So if they had stated that this contract should be governed by the laws of Colorado, then they will have implied in that contract. So Kenya's courts do not have the jurisdiction or the mandate to settle a dispute if there was a clause that stated the laws that should be applicable. So these courts of Kenya do not have that jurisdiction to determine any dispute that arises within that contract. So that is express autonomy. And implied autonomy, the courts enter or continue. So under here, the court infer the laws that the parties to the contract would have intended or would have implied to be appropriate by looking at the body of the contract and by considering the conduct of the party. So what was the intention of these parties? Which laws did they intend to be relied in case of dispute? that conduct, how did they conduct themselves? So what was their intention? Did they intend Colorado laws to be applicable here, or did they rather intend Kenya laws to be applicable? So that is under implied autonomy. They look at the intention and the conduct of the parties. So, and the second approach, we have got, before we look at the second approach, we look at the limitation to the autonomy and party autonomy. The parties must choose the laws of a bona fide legal system. That is the limitation. The laws must be of a bona fide legal system. And you can't avoid mandatory rules of the customs and trade of your area. So you've got those customs that guide people within a particular area. So you cannot disregard these customs and mandatory rules of that particular area. That's the limitation. So the second approach that is provided by common law is the place with the most real and substantial connection. And under this, we have got two approaches: the center of gravity approach and business efficacy and efficiency approach. So under the center of gravity approach, they look at the connecting factors, I think so, localizing elements. So under the center of gravity approach, they look at the localizing elements. So where the localizing elements are densely populated, then that place is where they place the center of gravity. That is the place with the center of gravity. And that is the place that is considered to be the place with the most real and substantial connection. So where there is the localizing elements are sparsely populated, then the court will not place there the will not that will not be the place to the most real and substantial connection, but rather the court will refer to the place where this contract will be performed to be the localizing element. So the localizing elements are connecting factors. Where they are densely grouped, it becomes our center of gravity. Where they are sparsely, the courts will attach weight to the localizing elements of attach weight to localizing elements to the law of the place where the contract is to be performed to be our connecting factor or our center of gravity. So, for example, like we have got a contract that has been entered between parties who stay in Kenya and parties who stay in Colorado. So if the court determines that the localizing elements are sparsely placed or are densely placed in Colorado, then Colorado will be the place with the most real and substantial connection. Thus, the center of gravity will be placed in Colorado. And if they found out that the Colorado is the localizing elements are sparsely populated in Colorado, then the court will have to place will refer to the place where the contract was to be performed. The contract was to be performed in Kenya. Then Kenya will be the place with the most real and substantial connection. Thus, they will place the center of gravity in Kenya. So the second approach is the business efficacy and efficiency approach. And the court considers whether where the party reside or do business. So it was illustrated in the case of Sears versus International Drilling Company Limited. So where was this contract supposed to be performed? If it was supposed to be performed in Kenya, or where these people do business in Kenya, then the contract will be the laws of Kenya will be used, but not the laws of Colorado. So that is the end of this episode on choice of law rules, and just subscribe to Sports Legal channel. So in this episode, we'll be talking about choice of law rules. We were just looking at the appropriate laws to be used in private business. So that is the end. Have a nice day. Come on, guys. We